Mistake number 5. Talking to the police without an attorney. What to do if the police ask you to speak with them voluntarily? Should you talk to the police if you are a suspect? The answer is no. But what if you are innocent? The answer is still no. But what if they just want to rule you out as a suspect? No. But what if people will think you are guilty if you do not? You are not listening. No, no, no. There is no scenario that will lead to a different answer than no. Okay, so you have good intentions. You want to be helpful. You have been led to believe that a quick conversation with detectives will clear up the confusion and get this mess over more quickly. Naturally, you are eager to address the issue directly rather than hide behind your lawyer, as they say. Innocent people don't need lawyers, right? Wrong. The problem is that you do not understand how an interrogation works or what its purpose is. An interrogation is not a search for truth. It is a search for a conviction. It is an opportunity for the police to collect additional evidence to confirm their existing suspicion so they can arrest you. It is a game that they are playing, and you don't even know the rules. How could you expect to win? You think that you can nice your way out of suspicion by going along with the police's request, but you cannot. The police are not your friend. They are doing their job, which is to investigate and prosecute crimes. The good cop routine is part of their training to pull out additional information from you, a psychological tactic to encourage you to be more forthcoming. Google the read technique if you think that the police don't have this mind screwed down to an exact science. If you cannot resist the seductive temptation to be voluntarily interrogated, then you might as well pack a toothbrush for your eventual jail stay. If they had everything that they needed, they would have already arrested you, and you're about to waltz in there and give them the missing pieces. When the police ask you to sign here, here, and here on the form that waives your 5th and 6th constitutional protections, will you begin to see that this is a terrible idea? Here are some of the tricks that police can and will use against you. They can lie to you and tell you that they found your DNA. They can pretend that a witness identified you at the scene. They can say that your spouse is in the other room writing a formal statement against you. If your story is too consistent, they will say that it's made up. If your story is not consistent enough, they will say that it's made up. If they don't like your version, they will have you go over it and over it until they can interpret it differently. If they can't get an actual confession, they'll settle for word games and mind games. If they believe that you have confessed, they will stop investigating the case for alternative explanations because they think your statement seals the deal. Don't let the police make you feel guilty for refusing to be a chump. Here are a few true stories, similar to what you may encounter if you don't have an attorney present. I represented each of these defendants and did not make these facts up, so don't dismiss these warnings as something ripped off of primetime television. The one-question curveball. A man was accused of shaking his baby to death. The police told him that they wanted to just ask him one question. He went to be questioned, believing that the police would just ask him whether he shook the baby or not. After 3 hours of answering the same questions over and over again, he finally said enough. At his trial, the interrogating officer said, "Man, you should have seen how quickly he ran out of the room when we started turning up the heat." The man's cooperation was used against him even though he said nothing incriminating. The recent Supreme Court case of Salinas versus Texas held that if you have been placed in custody and have not received Miranda warnings, and you voluntarily respond to some questions but not others, the prosecution can use your silence in response to the later questions as evidence of your guilt. The helping hoax. I represented a man who had a limited education, which was immediately obvious to anyone who met him. The interrogating officer continued to use the word provocative to describe the minor's behavior, and he insisted that the man agree. My client was too embarrassed to admit that he did not know what provocative meant, so he just started saying sure to everything that was asked. The man trusted that the officer had his best interest because the officer kept telling him that he liked him and wanted to help him during the interrogation. During the trial, the officer kept repeating the word provocative as if it was something the man had originally come up with himself. I confronted the officer at the trial and he finally admitted that he brought the word up first. I also asked, "Did you make a promise to help my client?" He grinned widely and said, "Sure did. I helped him right into a jail cell." Even though the jury thought it was a sleazy tactic, they still convicted the man in large part due to the perceived confession. The guessing game. A man went into an interrogation and could not remember what happened the night before because he drank so much he passed out. The police asked him over and over what happened, and the man kept insisting that he did not recall the prior night's events. The police then shifted their tactics and came up with a list of complicated, made-up scenarios, all of which would make the defendant guilty. The police then asked, "Maybe it happened like that. Is that possible? Is it? We're not saying that you did it or that it went down that way, but you must admit that it is possible if you don't even remember that night." Since the man had already said multiple times that he didn't know what had happened, he said something like, "I guess that is possible, but that would not happen because that is nasty and I'm not like that." The man agreed that the act was possible in the factual sense that he and the minor victim were not 500 miles away from each other on the night in question. The officer then went to the trial and testified. I asked the defendant whether he molested that little girl, and he nodded his head up and down and he said that it was possible. He can't remember for certain, but he believes that he might have done it. The officer suggests that anything possible is also probable. The fact that there is no forensic evidence to support such an act was lost on the jury, and the man was convicted for the offense. This jury verdict might as well have read, "Guilty of guessing." The 40-fact fraud. A woman insisted on going into an interrogation without an attorney. The interrogating officer asked questions that were nearly a half-page long. The officer packed nearly 40 facts into the question and then asked, yes or no. When the woman nodded her head up and down, the officer interpreted that to mean that she accepted the entire statement as true, but the woman's agreement was merely that the officer had gotten the story basically right. She didn't know that it was considered an admission of all of the extra tucked-in facts. At trial, the officer gave the jury the impression that the woman had specifically agreed with each individual fact and did not reveal how the facts were snuck into a 3-paragraph question. And of course, if the woman had broken down the questions into a lengthy explanation rather than provide a yes or no answer, the officer would have testified that she was being evasive. The revision ripoff. An officer told a defendant that he must have had his timeline wrong because a toll gate camera proved that he passed over a bridge at a very specific time. The defendant, not aware that the officer can lie to him, did his best to revise his timeline to conform to this known fact. The defendant thought that he and the officer were figuring it out together because he did not know that the officer was lying the entire time. At trial, the officer testified that when I confronted the defendant about his whereabouts, he admitted that he originally lied about his timeline. It was never revealed that the officer lied about the toll gate, and the toll gate footage never came out. The officer never revealed the twisted context that resulted in the defendant trying to retrace his steps. The timeline was not even material to the case. The officer just wanted to be able to say that he had caught the man in a lie. The polygraph pinch. An officer invited a man to take a polygraph test and said, "What is the harm? The results of the lie detector test aren't admissible anyway. You will be ruled out as a suspect if you pass." The results of the test were inconclusive, and the officer used the semi-incriminating statements from the polygraph test to harass the man for nearly a year before the charges were finally dismissed. The results of a polygraph test are not admissible, but the statements made during the test are admissible. The police cannot show that you failed, but you also cannot show the jury that you passed. And by the way, you will not pass the test. It will always show up as inconclusive when the results are in your favor. The sex sales scam. A defendant accused of having intimate relations with a minor had been sitting in jail and hadn't seen a woman for over a week. Although a lawyer had been appointed to represent him, an attractive, nice-smelling female polygraph administrator said she had come just to visit him and remarked what a shame it was that they wouldn't be able to spend some time together. He gladly waived his right to have his attorney present as the female officer touched the defendant's hand, smiled at him, and used suggestive language about how good-looking the defendant was. She later made statements about how lucky that girl was to be with such a handsome man. Later, the agent got hot during their interrogation and removed her jacket. This foolish defendant thought the female officer was genuinely attracted to him. He learned, however, that if he did not flirt back with her or go along with her sexual suggestions, the officer would clam up and say, "Well, maybe we just need to take this polygraph test and I need to get out of here." As long as he played along with her dirty talk, she continued to pour on the sugar. Naturally, she was secretly recording him as he responded to her sexual questioning. Although this female was qualified to conduct polygraph tests, she enjoyed concluding her test by bragging to other officers how she never even turned on the machine. Instead, she turned on the defendant. Later, the prosecutor edited out this agent's inappropriate discussions from the interrogation. The prosecutor also tried to make sure that the agent wasn't available to testify at the trial and only wanted to introduce the defendant's statements. It took a special defense motion to get the entire conversation between the officer and the defendant, rather than just the defendant's confessions. Note: even after you've hired an attorney, the police can continue to try to get you to talk to them. It is your right to have an attorney present, but you can waive that right, which is an incredibly dumb thing to do. I always give my clients permission to use me as an excuse for why they can't attend a police interview. They say, "I wanted to come visit, but my lawyer won't let me." The police may not like it, but they must respect it. The off-the-record ruse. When you go to the police station voluntarily, the police do not have to read you the Miranda warning, so do not think that your words are off the record. Even if you convince them to turn off a recorder, they can always testify to what they heard come out of your mouth. Off the record does not exist. You and the interrogating officer do not have a gentleman's agreement, even if the officer really liked you and saw that you are the real victim here. This is all just the good cop routine. The privacy ploy. A young adult is in the police department's interview room, interrogation room. The officer calls the young man's mom and tries to get the mom to guilt the boy into confessing. The boy asks if the officers can leave the room so that he can talk to his mom privately. The officer smiles and says, "Absolutely, because there is a secret camera and microphone hidden in the wall clock." At trial, the police insist that the boy should not have had a reasonable expectation of privacy, and the footage is used against him. Perhaps these officers have good intentions, but their games are often more about trying to outsmart a nervous suspect than getting to the truth. Remember that a false confession not only incarcerates the wrong person, it allows the guilty person to go free. Even people who are tough on crime should want to get the right results. You will get your chance to tell the truth later on the stand. Tell the jury directly what happened if you want to explain. But until then, zip it. What to do if the police interrogate you non-voluntarily? Even though I hope I've convinced you not to speak with the police voluntarily, in some cases, you don't get a choice. This section addresses how to handle a non-voluntary police interrogation. If there's one aspect of criminal procedure that most Americans are familiar with, it's the following famous phrase: "You have the right to remain silent." Anything you say can and will be used against you in a court of law. You have the right to speak to an attorney. If you cannot afford an attorney, one will be appointed to you. Do you understand these rights as they have been read to you? But what happens when a defendant is never read his or her rights? In Miranda versus Arizona, the Supreme Court of the United States case held that police must give a Miranda warning above to criminal suspects prior to custodial interrogation to make sure that the person is aware of his or her constitutional rights, specifically the Fifth Amendment right against self-incrimination and the Sixth Amendment right to have an attorney present during questioning. If the police bring out an incriminating statement from a suspect without reading the Miranda warning or Miranda rights, then the statement will not be admissible. If the suspect receives the Miranda warnings and makes a knowing, intelligent, and voluntary waiver of his or her rights, then any self-incriminating statement made is admissible. Admissible means that it can be used in court. Notice two things. The Miranda warning is only required prior to custodial interrogation. This means that you must be 1, in police custody, and 2, be subject to police interrogation. Therefore, no Miranda warning is required when you speak with the police at your house, at your job, standing on the corner, etc. No police custody. Also, just because you are at the police station doesn't mean that you are necessarily in police custody. The test is whether a reasonable person would have felt free to leave. If not, you are probably in custody. Therefore, if the police call you and ask you to come down to the station just to talk, and you voluntarily go to the station and make self-incriminating statements, then Miranda is not required. What about if you didn't feel free to leave the police station, but you volunteered a statement while waiting for your lawyer to arrive during a time when the police had halted questioning? Imagine that you blurted out a self-incriminating statement on your own. That statement can be used against you because you weren't being subjected to interrogation. A suspect can invoke his rights and then waive the rights that he or she just invoked merely by speaking about the case. The only punishment to custodial interrogation without Miranda is that the police lose the ability to use the self-incriminating statements. The police don't have to drop the charges against you. They don't have to immediately let you go. And they aren't subject to civil liability merely for failing to Mirandize you. It's actually common for police not to give the Miranda warning. Imagine that the police are called out to investigate a possible aggravated burglary claim. They arrive on the scene to find a suspect walking out of another person's house without the owner's permission, with a bag full of stolen items taken from inside the house. The suspect is caught red-handed and immediately arrested. In that situation, the police have all of the evidence that they need. They do not have to take the suspect back to the station and try to pull a confession out of him, custodial interrogation, because they have firsthand knowledge of his offense, and they can testify to what they saw. The big rule here is that if a person is subjected to custodial interrogation without a Miranda warning, or he or she invoked the right to remain silent, and the questioning wasn't halted, then any self-incriminating statements made would be inadmissible. However, you can see from the above analysis that Miranda is not required in many situations. Miranda protection is not as broad as you probably think it is. 3 recent U.S. Supreme Court decisions have reduced Miranda protection even further. The court recently decided in Burgess v. Tompkins that a suspect must unambiguously invoke the right to remain silent by telling police that he or she wishes to do so. That means that you got to be very clear about it, or it doesn't count. If you sat silently and did not express to the police that you understood your rights, and during continued interrogation answered a question to the police, then the statement is inadmissible. You have not waived your rights because you haven't explicitly said, "I wish to remain silent." Therefore, no Miranda is required. This is similar to the requirement of a suspect to tell the police that he or she wants a lawyer, as held in Davis v. United States. The court also held in Maryland v. Schatzer that a suspect who invoked his right to remain silent must do so again after a 2-week period. This amount of time is to allow for a person to be reacclimated to normal life and free from the pressure of custodial interrogation. The rule is not once invoked, always invoked. The court also held in Florida v. Powell that while Miranda requires a suspect to be warned prior to any questioning and that he has the right to the presence of an attorney, police must only reasonably convey this warning. In the facts of this case, the police did not explicitly indicate that the suspect had a right to have an attorney present. The court felt that the warning was sufficient and upheld the defendant's conviction. So, when they aren't very clear about it, it does count. Based on these recent cases, a suspect may find the best reaction to custodial interrogation is to say, "I wish to remain silent and I want a lawyer," and then not another word, and then not say another word. If subjected to custodial interrogation at any later time, the suspect should repeat the above statement prior to each custodial interrogation. If you already have a lawyer, then tell them that you want your lawyer to be present, and then don't say another word after that. Note: This is not a complete review of the thousands of cases regarding Miranda, and should not be taken as such. These are just general principles. The United States Supreme Court is continually chipping away at this, so if this book is getting some age on it, just assume things are even worse now.